Hey, I'm Marc Stevens, author of Government Indicted, website, of course, marcstevens.net. And it's a little different. I got to plead ignorance here. I did not ever hear this particular phrase before. Somebody had gone to court in Canada and reported this back to me, that when they questioned if the prosecution had presented sufficient facts proving that their Constitution and Code applied, the judge shrugged it off with this phrase, "It's trite law." And I had to look it up. I thought maybe, I had never heard it before. It's trite law. And with no reference to any facts, nothing about a competent witness, he just shrugged it off. It's trite law. So I looked it up, and what I found was that things that are obvious, laws, it's the word there, laws, that are common knowledge. Trite law is law, if you do not know it, you should. It's like saying that 2 and 2 is 4. For example, there is a presumption of innocence in Scotland. That is trite law, something that everybody knows. I hear that last part, and the logical fallacy alarm goes off in my head. We definitely have an appeal to popularity, but we'll get to that. I think at best this is being, it's just being misapplied. Although I don't think the judge is doing that. Canadians seem to have this. The judges that we've had some experience with just have this habit of just relieving prosecutors of their burden of proof by just saying, "Oh, you have all this evidence against them. Oh, it's of no moment. It doesn't matter." And so here you're asking for evidence, and he says it's trite law. Everyone knows that. What? Because it's saying here that trite law is law. It's not about evidence. But, like I wrote in the article, which is at marcstevens.net, at worst, the judge is just covering for the prosecution. And that is what I believe is what's really going on here. It's called a felony known as obstruction of justice. The prosecution obviously doesn't have the evidence, and the judge is covering. So first we'll cover the misapplication. This is similar to what they do in the United States when they say that you ask for evidence proving the Constitution and Code because you're physically in the United States, and they try to take judicial notice. Well, we request judicial notice of that. Well, you can take judicial notice of what the law says in California, for example, on the Section 455 of the Evidence Code, or if you have facts that are not subject to reasonable dispute. That's not what's going on here. It is subject to reasonable dispute. And what they forget to tell you is that when they do a request for judicial notice, that if there's a timely objection, the evidence has to be put on the table. Just because something is obvious doesn't mean it doesn't have to be proven or can't. It's actually very easily proven. It's easy to prove something that's obvious because, well, it's obvious. So, an example of trite law would be that the Constitution is the supreme law of the land. That's what it says. It doesn't mean that that applies because it says so, because that's a logical fallacy. It's not evident. But that's what it would be. That's an example. It's not about practical application of the Constitution where somebody makes a legal claim that, hey, your laws apply to me just because I'm physically in Canada. It's just the existence of the particular law. It's law not to kill people. It's against the law. You should know that. It's a law, Section 139 of the Canadian Criminal Code, which is apparently, ironically, what the judge, violated. You should know about obstruction of justice because it's being dishonest. That's trite law. Section 139 is trite law because you should know that obstruction of justice is a crime. Did the judge who made the remark that evidence the Constitution applies as trite law, did that violate Section 139? That requires evidence. I can't just say, it's trite law. You violated the code. Where's your proof? It's trite law. See, it's not trite law as that is not theoretical. Theoretical, yes, would be trite law. Second, did the judge cover the prosecutor's burden of proof? So I don't think it's an innocent misapplication. I just think that it's on purpose, that the judge did nominally cover the prosecution's burden of proof. It's not just an issue of jurisdiction, it is definitely an element, an essential element of the charge. There is no crime without the code. It's a code violation. There's absolutely no wrongdoing unless the Constitution applies first, because you're only being charged with something that's wrong because a politician said so. Their laws passed pursuant to the Constitution forbid it, but if the Constitution doesn't apply, okay, they call that a mala prohibita law. That's only wrong because a politician thinks so. So look, the prosecution bears the burden of proof. That's easy enough. Even if something evidentiary is claimed to be obvious, that does not relieve them of their burden of proof to prove it beyond a reasonable doubt. 2 + 2 is 4, but if challenge can be proven to be true, okay, I can prove it. 2 and 2. So we got 1, 2, 3, 4. Trite, obvious, provable. You can demonstrate it. We all know that George W. Bush is a war criminal. Can we just prove that by saying, well, it's trite law? He violated the rules of war. He violated international law. Where is my proof? Just saying it's trite law doesn't relieve you of the burden of proof. Just saying it's obvious doesn't mean you don't have to still prove it. You still need evidence of the wrongdoing, such as they knew there were no weapons of mass destruction and they sent people out there to kill anyway. That is evidence. So what I like to do is flip things around. Whenever they're using something or doing something and letting the prosecution get away with it, flip it around and see if they'll let you do that. And they'll tell you that they'll tell you real quickly that that's not permitted. Now you got it exposing a double standard. So imagine me saying to a judge, well, excuse me, sir, but your constitutional laws don't apply. That's trite law. You should know that already. And no judge is going to say, brilliant! No. Imagine me saying, no. Your Constitution doesn't apply to me just because I'm physically in California, Canada. It's trite law. You should know that. The judge would come back and say, no, I don't. I don't think that relieves you of your burden of proof, Mark. And I could just say, well, it's of no moment what you think. That's an actual statement from a Canadian judge. The example was that they were laying out the facts that the prosecution and the judge are on the same team, that was a conflict of interest. And so the judge said, the fact that the judge and prosecution are on the same team and are paid by the same treasury is of no moment. It has no bearing on whether there's a conflict of interest. So there's no moment. The last thing is it's a logical fallacy. To just say that something is true because everybody knows it or should know it, that's not proof. Argumentum ad populum. It's an appeal to popularity. We could turn that, again, turn about. It's fair play, right? See if they let us get away with it. Everyone knows that lawyers are dishonest crooks. Everyone knows that politicians are lying scumbags. Does that make it true? Well, no. The mountain of evidence does. I had an IRS try to pull that crap with me, that everybody knows. Everybody knows if you work you have to pay taxes, and I said, really? Everybody knows everyone who's a Sicilian is in the mafia. I'm half Sicilian. I must be in the mafia. Well, she dropped her appeal to popularity real fast. So, and that's what you can do. Always turn it around on them in the form of a question. Oh, I see. So break that generalization and then go for the throat. Logically speaking. So now you know if you're confronted with this so-called trite law, you know how to respond to that. You object. It's just a lame attempt to cover for the prosecution's burden of proof. Object often and strenuously, but still put your objection in the form of a question. What I like to say would say, objection, are you really making an appeal to authority on behalf of the prosecution? Give them 2 things to respond to there. So look, just remember, if there's evidence proving their laws and their rules did apply to us, they would just present it. They wouldn't say stupid things like it's trite law, you should know that. Everybody knows. You still have the burden of proof. If you had evidence proving your Constitution and laws applied to us just because we're physically in Canada, you'd just present the evidence. You wouldn't relieve the prosecution of the burden of proof. And just the other day, I spoke to a county attorney in Texas. She agreed and insisted that if you're physically in Texas, their constitution and laws apply. When I asked her for proof of that, all she could do is say, well, but you're here. So as your proof by assertion fallacy again. You just keep repeating it. We're in an echo chamber here. I know. How does my physical presence in Texas, how does that prove your constitution applies to me? The county attorney stated that she was not the one to answer the question. The only reason why I was talking to her was because another doctor, so again, I don't know if she had a doctorate degree in law, I don't think so, but she had a doctorate degree. And from the county commissioner, she was the one that said that she couldn't prove that her constitutional laws applied to me or anyone else because we're physically in Texas. So she was the one that referred us to the county attorney, who then said that she was not able to answer the question. And I tried to get a follow-up to that because I wanted to ask, you're not qualified as a Juris Doctorate to determine whether the Constitution and Code apply to somebody, but you're qualified to prosecute people that the cops have said. Cops who don't have advanced university degrees. So somehow they're qualified to make the accusation and testify against somebody that you can then prosecute, but you can't determine on your... If they had the evidence, they would just provide it. Ridiculous. So whether they say it's trite law, whether they say they don't have to, they're just proving that they're criminals. They can't prove their laws apply to us. And saying that they're not required to, you're just confirming that they're crooks. If you don't have to confirm that your claim is true, you're a crook. If you have a system in place, you're a crook. You're dishonest, you're a crook. End of discussion. And well, no, it would throw in that you're forcing perfect strangers to give you money. That's just more evidence you're a crook. So, anyway, trite law, it's a joke. It's nothing more. Nothing more than, hey, it's obvious to us that since we're the government, we have this prison system, we don't have to prove anything to you stupid little plebes. Hey, you want proof that our laws apply to you? 2 million people in prison, jackass. That's how criminals talk. But that's exactly what they are. Because when you force perfect strangers to give you money, you're a crook. It doesn't matter if you build roads. You're a crook. Using the stolen money to give gifts and provide nice things to your victim doesn't make you any less a crook. You're a crook. Well, my name is Marc Stevens. You have a disagreement with my analysis here, if you think I've gotten it wrong, or if you think that there's evidence proving that the Constitution laws apply to us just because we're physically in Canada, give a call into a live broadcast. I'd love to hear the evidence. Again, the website, marcstevens.net.